aquela pressão e ansiedade, né?
Mas começa às 10h30 a sua.
Não, o meu começa às 11. Às 10h30 nós vamos linkar aqui para fazer os últimos ajustes aqui.
Entendi.
Ainda que esteja na qualidade de moderador, é sempre um papel importante aí, né?
Opa! Às vezes o moderador faz mais do que o palestrante.
É verdade. Às vezes o moderador tem que resolver o problema do palestrante.
Ô, Beth, isso daí aconteceu lá em Porto Rico, na ZIP, lembra? Eu saí daqui como moderador, cheguei lá como palestrante, só apareceu um palestrante, aí eu tive que criar, invente. Até violão eu toquei no
Foi isso mesmo.
Viu? Moderador também é palestrante, mais ainda, acho.
Não, mas a ideia aqui exatamente é dar mais tempo para os palestrantes falarem, mas na falta de um a gente vai ter que criar e inventar aqui, mas vai dar tudo certo, tá tranquilo.
Vai, com certeza.
E contando com a participação dos perguntas para eles também, né? Porque é isso que dá uma motivada ali no desenvolvimento das ideias.
Você vai falar sobre esporte, né?
Na verdade, vou falar sobre contratos, os direitos de transmissão e de arena, né? Que teve uma MP aí, eu acho que mesmo quem não acompanha muito ficou.
Senhoras e senhores, nossos associados.
Ladies and gentlemen, all those who are with us this morning, very good morning. We are going to start our second plenary in which we are going to discuss fake news. Fake news is a topic that has been in the forefront of news worldwide in recent months, from accusations of public opinion manipulation in the Trump election and Brexit voting to spreading false accusations against politicians, business leaders, celebrities in Brazil and elsewhere. There's no question that the wide dissemination of fake news widely disseminated can lead to wrong choices and dangerously hurt individuals, organizations, government, or even entire countries. There's also no question that the web, in particular social networks, are tools capable of disseminating news and information at unprecedented speed. They probably have less possibility of introducing filters and safeguards than the conventional systems, which were more centralized, such as newspaper, radio, and video broadcasting. On the other hand, this debate cannot fail to take into account the benefits that the same technologies provide as they speed up the dissemination of truthful information, sometimes able to having a life-changing impact, avoiding damage, including catastrophe, and also disseminating practices and actions of collective interest. Sanitary measures to prevent COVID, widely communicated and disseminated in social media, is an illustration of such positive result. This is also an example of the difficulty that often arise when it comes to distinguish true from false. Even cautiously communicated scientific results can be denied by evidence that only subsequently will come to light. From chloroquine to the use of masks, whether its effectiveness is true or false, remains an issue that has not been entirely solved. Who can categorically state what is true or false? If a minor doubt remains unanswered, and this is always difficult to settle, fake news control can dangerously come closer to censorship, which was duly and timely banned in the Brazilian 1988 Constitution. I'd like to give the floor to our moderator, the president of ABPI, Dr. Luiz Henrique do Amaral. Good morning. ABPI is holding this Congress entirely online. I'm going to be the moderator of this plenary session. We've discussed for a long time the internet framework, and when the discussion was over, when finally it was approved, we thought we'd have a period in which issues related to internet, IP, protection to information, freedom of speech, limits, somehow be already part of this framework. But the reality, especially in the technological area, bypasses our expectations very quickly. And once again, we are debating fake news, and especially we are focusing on the mass messaging system, which is sending bulk messages containing true or false content. And then we ask ourselves, what would be the limit to use such tools to mass disseminate information? What are the limits of legality? What is acceptable in our legal framework? So this morning, we are gathered here precisely to debate this issue. And initially, and of course, we also thank the presence of the Deputy Secretary of Communications, Mr. Coimbra, who will be the first to take the floor. And before he takes the floor, let me briefly introduce Dr. Arthur Coimbra. He is the director of the investment for telecommunications investments enhancement under the Ministry of Telecommunications since 2011. He has a degree from the University of Brasilia. He's also a member of the study group in the University of Brasilia. He's a specialist in regulation, and he is a federal prosecutor. He worked for Anatel and for the Strategic Topics Secretary in 2009. He was also part of a group that drafted the national program for wideband. So he is highly qualified to start debates this morning on this very relevant topic. You have the floor, Arthur. Thank you, Luis Henrique, for your introduction. I'd like to thank you, to thank ABPI for the invitation to come to this event discussing such important issues. I would like to greet all the other members of the panel and also all our audience. To deal with this topic of fake news, it's very important to set the stage worldwide and to verify the impact it has in contemporaneous democracy. Information, what we call false information, what we call the fake news, is a problem impacting democracies all over the world. The use of a social network, private messaging, and other systems, when unduly and maliciously done, may bring about a division in the debate, which brings instability to institutions. One drastic event happened in Myanmar. There, the armed forces promoted a campaign against a minority, the Rohingyas, and the images that were shown in a different context, they use these images and these news to incite the population to go after this minority, which accounted in the end for a very, very large amount of casualties and also those who had to flee the country because of this persecution. Another very widely known event is the case of the British company Data Analytics that was mining data for electoral campaign. In 2016, this company was involved in the US presidential election as well as in Brexit. Their advertising strategy involved analysis of behavioral profiles of different groups, especially in Facebook, to identify their political opinions and also to assess their voting trends. So the users were divided in groups, and the company would focus on those who were more vulnerable to changing their voting position. There are suspicions, for example, that categories that were established were based on certain ethnic groups and how they vote. So there are many suspicions, not everything is clear, but it shows the manipulation power of these social networks and the spread of misinformation. Of course, in our current situation under a pandemic, it couldn't be any different. And there are many examples of misinformation in terms of the COVID-19. Miraculous solutions, different theories that came to the surface. And some of these theories involved accusations, involved countries and governments of countries motivated by ideology, and even technology became the target of lack of information. For those who work with telecommunications, we've seen that in the UK, some people were instructing 5G communication towers because they were seen as points of disseminating the virus. So they would against it, they would instruct people to destruct it. So in New York, we had the example of people who injected disinfectant because they believed it could fight the virus. The international turmoil was so significant that the World Health Organization had in its portal more information about it to clarify such points. The same thing was done here in Brazil by the Ministry of Health. One common point when it comes to disinformation is polarization of debates. Due to the filtering systems, we users can be given only what confirms or what validates their own opinions. So this is what we call the ideological bubbles or chambers of echoes, because we are reinforcing ideas among a group that is like-minded. Another point is the analysis of digital profiles. Given these personal data mining that is carried out, and because millions of users are controlled, some ill-intentioned groups can locate some groups which are more likely to disseminate false information. So this process is disseminated widely and very fast. So what would be the best way of fighting this occurrence? And let me stress that the problem is highly complex. It's very, very difficult to think of a state controlled action that would significantly mitigate a misinformation threat. Legislation, however, may bring about guidelines that will orient different players, whether they are journalists or they are users. So a project that would promote transparency is very welcome, as long as freedom of speech is not hurt by that. So we have to be very careful when establishing principle and guidelines. The issue related to content, we have to be very cautious about it, because if it's rigid, it compromises freedom of expression, and the contrary is ineffective. So we have already certain rules that may contemplate that, except for some exceptions. The proposal of a self-regulation is also very interesting. This is a model that is adopted in other countries such as Germany, Australia, and in the European Union, in other countries. And what does that mean? Companies will create their own regulatory agency, and they will establish certain practices. This agency is monitored by the state, and they have to submit periodic reports, always under the supervision of the government. But we have to understand that this model is also subject to criticism. There are people who question the effectiveness of such system in fighting misinformation. Another point that we have to think about is the creation of new types of crime in our legislation. There's no question that those that are disseminating malicious messages, encouraging hate actions and hate messages, this is criminal. And the question is, the existing criminal types, do they cover such actions? It's very important that any contemplation in terms of creating new criminal types, we should be very careful so as not to bring about any danger to freedom of speech. So we have to distinguish what is ill-intentioned and what is carelessness. Most of the people incur in carelessness when they spread news under these systems of misinformation. I also would like to stress that the general law on personal data protection is related to fake news. We've discussed that yesterday with the directors of this agency, and some items that should have been contemplated in the LGPD are being studied, because this is fundamental to fight misinformation. So let me conclude and let me thank you once again for this invitation. I would like to reinforce the message that fighting misinformation is a duty of all of us, and that no legislation alone will bring an answer. It's very important, but it's only a starting point. Other players have to engage so that the process can be successful. Thank you. Thank you very much for your intervention and your comments. Let's consider here this difficulty precisely of finding a balance between freedom of speech and accountability in case of abusive actions and actions that go beyond the freedom of speech. It's not an easy discussion. It requires a lot of care, and it requires an examination. And I would like to present the next speaker, who's going to talk about the so-called fake news. Senator Angelo Coronel is from the state of Bahia. He has a degree in civil engineer from the Federal University of Bahia. He was the mayor of Coração de Maria, the municipality in Bahia. He has had a mandate for 4 terms, and he is the leader of the Bahia Assembly. He was elected in 2018, and he is the head of the commission studying fake news. He is also the rapporteur of the law on the bill on fake news, which is Law 2630. So we are very pleased to have you here, because you are precisely the representative in Congress that is at the very core of this discussion, and you have in your hands this responsibility. You have the floors. Let me greet our moderator, Dr. Amaral, Dr. Coimbra, Dr. Rigoni, and all the members of this panel. I'd like to greet ABPI and compliment it for this Congress, which is extremely relevant for our country. When we talk about fake news, and I have to tell you that when I go around in Brazil, I get approval and a lot of disapproval too, because this is a very hard topic. There are people who love fake news, and there are others who had their families dangerously impacted, or their products being smeared, the target of smear campaigns. We had a minor problem with the sound. Okay, so let me repeat. Those who engage in fake news dissemination, they probably think they are superheroes, because they are able to heavily hurt the image of a company, a person, or interfere in a process such as the vaccine. In terms of the law, the 2630, I will refer to some topics. This bill was taken to the Senate, and it is waiting a discussion for 4 months. I have
repeatedly asked the leader, Rodrigo Maia, so that this process can move forwards. We need a new rapporteur, and if there are changes introduced in the report that I submitted, it will come back to me in the Senate so that I can agree or disagree with the amendments proposed. And it's only after that that it will go to the president to be sanctioned or not. And even after that, we can go against the presidential veto if the decision is reaches this point. I'm just describing this so that you all become aware of the process, the legal process. In terms of the law 2630, in terms of guaranteeing freedom of speech, there's no censorship whatsoever in my report. Content can only be removed under a judicial order. There are few exceptions, which is inciting violence, inciting suicide or self-mutilation, or the cases of pedophilia. There is a current, there is a trend saying that my report abridges the freedom of speech. This is not true, because you have to understand that freedom of speech is nonetheless subject to limits. You can't just say anything about anybody believing that you are protected by the Constitution. This is not true. We are going to fight those who think that they own, that they are the owners of freedom of speech, and they can offend whoever they want. So that's one front. The other front is anonymity, which is also in the Constitution of '88, requirement for documentation for message services or for the roster of social services. The identification of users will be the responsibility of the networks in case of identification of robots or automated accounts, as we say. So if, for example, in Facebook, if we see that there is someone who is conducting a smearing campaign against a person or a product, this person or the owner of the product can go to court to find out who has that site, who is the owner of that site, so that actions can be taken. So not at all in my report, I want to expose the identity of people. If that happens, it will be a consequence of a legal order, a court order that will allow disclosure. Also, in case of accounts operated by robots, this has to be disclosed because users have the right to know whether they are talking to robots or not, because this may hurt public services or let's say vaccination campaigns, or in the case of the alert for floods. So mass messaging or bulk messaging sent illegally, this is also another example, and this happens in elections. Well, we are going to have elections in less than 30 days, and we know that bulk messaging is taking place. Some messages aim at supporting the candidate, and others aim at bringing a negative view. There is an agreement between WhatsApp and the Superior Electoral Court, and yesterday in a conference with the director of WhatsApp for South America, we discussed that point. I asked him, what would be the practical effect of this agreement, WhatsApp and the Electoral Court, if a candidate states that he is being the target of malicious messages or a smearing campaign? WhatsApp will be communicated. And though if WhatsApp says, well, I have no way of disclosing the identities, then this agreement is not worth much, because if you don't discover who is the criminal acting using that service, then there's no point. You are totally helpless in terms of actions to be taken, and you have no right to respond to what is being said. I always argue that the right to answer is something sacred in our legislation. You cannot have your honor impacted without having the right to defend yourself, because you don't have this space in a messaging system such as WhatsApp. The report also established systems to protect the user through a moderation of content done in the platform. So what I mean is, we have the right of defense, and the platform is not sovereign to just discard or to remove anything that has been posted. If someone posts in a way that there is anonymity, then we can say that there's no origin. But if a message has an identification and someone believes to be hurt by that post, then Facebook has to notify whoever is sending these messages, so that there is a possibility of response. And if it's not satisfactory, the content has to be removed. And moderation will be transparent, and the platform should present a quarterly report to the council, the Transparency Council, which was created in the 2630 project.
Transparency and sponsored content or pushed content have to be identified as such, so that users understand who paid for it and who's responsible for it. A member of any of the three branches of power, an individual or anybody belonging to a party, may be a party to the Board for Transparency, the Committee for Transparency is going to be a very comprehensive committee, a member of the federal police, of the lower house, the Internet Committee. It has a large representativeness. So all currents are covered, so the debate is profound and representative in this Internet Transparency Committee. Also, penalties for platforms that don't respect the law. These amounts are going to be invested in the Fundeb fund, an education fund for digital literacy. Today, Brazil has a gap in digital literacy. If you look at the syllabus of schools, there is no subject on digital literacy. So these penalties, the fines, will be invested in fostering digital training and education in Brazil. This is going to be very important. So our children and grandchildren, they start learning digital education early in school. We understand today is a global online digital world. So we need to make sure that future generations have basic knowledge, especially of digital subjects. Traceability, this may be the most controversial topic in the 2630 bill. Identifying and keeping for 3 months of metadata of virus messages in WhatsApp, applications. Traceability is going to be enforced on messages attaining over 1,000 users and that have been sent by more than 5 people in a 15-day period. Why? When WhatsApp was created, it was supposed to be a private message platform. Once WhatsApp included groups and lists of 256 participants, it's no longer a private platform. It's not a message to you, Coimbra, to you, Luis, because it's a public. So because it's a public messaging system, WhatsApp is challenging this article on traceability, and then they say that they claim that this is going to be a problem in terms of confidentiality. If you receive, Luis, a video denigrating your image, and then you bring that to a judge, and then the judge issues a court order so WhatsApp can find out who sent that video, if without a court order, WhatsApp is not going to do anything. In case there is a court order, WhatsApp is going to use metadata technology to find out who the digital criminal is. If not, you will never know who has posted that video attacking your image, and you become yourself a criminal or the good guy without being either, because nobody knows who has sent out these videos or information. So traceability, always like to repeat, it's not breaking, violating privacy. Traceability is done via metadata, meaning the way followed by the message, the person who first posted it, who's going to be accused of being the perpetrator of this crime. And this is going to happen through telecom companies used by the mobile phones. So there is no threat to cryptography. What we want is for them to save metadata that is going to make sure that it will be possible to identify the thread of forwarding messages. I'm going to read this again so I will make sure it's quite clear. The original sender of the message of illegal messages, and who's going to judge what's illegal or not? It's not us. It is a judge. It's not the person who's been attacked. It is a judge that is going to judge and sentence and issue an order to identify the criminal. Some people are saying, well, Mr. Senator, somebody may receive a message and very naively send it out. That person is not going to be prosecuted. We are going after the authors, the first one, the origin. So this is covered on my report. And in no way, in no chapter, in no article, we're not going to prosecute those who have forwarded the messages. We're going to prosecute the first original sender. There won't be a massive keeping of user data. After the 90 days, the metadata will be scrapped. There's no point to have that amount of metadata, a mountain of metadata. I know it's not a mountain, but it's a lot of data after 90 days. If there's no complaint, WhatsApp understand. There have been no complaints within 90 days. So then WhatsApp can scrap the metadata. We have a accountability and transparency. We're going to create a committee that is going to be formed by telecommunications representatives, civil society, and a number of others. It's going to be recommending policies, but it's not going to be an inspection body. I am mentioning this committee all the time. It's not going to be an inspection body. At the lower house, I have heard there is a change. It is the prosecutor's office that is going to prosecute. It is the justice system. The translation booth apologizes. There has been a small technical glitch. There's some kind of interference. We're getting a double speech. So this was not part of the initial bill, both for individuals as for corporations. The bill already asks the address and the full name. And now it's going to be identity number, and for the corporations, the corporate number. We are going to then have systems to verify these numbers so that we can identify users to clamp down on robots. The regulatory body and telecom companies will have to make sure that these registrations are correct. Today, for you to have an account at WhatsApp, you need to have a mobile number. If you don't have a mobile number, you don't have an account in WhatsApp. What's happening today? Digital criminals will have the SIM card inside the mobile phone, and then there's a number there. The English translation apologizes. Apparently, there is a microphone that's on. We're receiving 2 speeches in. Unfortunately, the translation is no longer possible as we're getting 2 speeches at the same time. A prepaid SIM card to make sure that the corporate number is correct. In the bill, I have placed that SIM cards to be validated must have the individual taxpayer validated in the SMS validation. The IRS data bank has to be available through the telecoms and the regulatory body, because if I use a fake tax number, I will not be able to approve the SIM card. And then they ask me, sir, we have 140 SIM cards that have already been approved. Well, then we're going to have to re-register. So telecoms are going to ask you to validate your tax number. If not, your SIM card is going to be canceled from by the telecom company. This is a way to clamp down on this weapon. This is a weapon for drug trafficking, for smear campaigns. It is through mobile phones when you open an account in WhatsApp with a fake SIM card, that digital criminals are smearing trademarks, and people in Anápolis, a locality in the state of Goiás and in Brazil, we already testing the intelligent URA. When somebody wants to validate a SIM card and placing it in the mobile phone, you're going to have an intelligent system that is going to make sure that you are the person who you claim you are, that this is a real tax number and it's not a SIM card for criminal purposes. So this is being tested, and I believe, but the whole of Brazil is going to start using, and the regulatory agency is welcoming our suggestions. The substitution bill approved in the Senate includes the accounts operated by a government agent. When you say public, a public account, public platform, the Facebook of the president has to be public. You can't ban anybody. You can't, because a public figure has to have a public account. I hate the example of the president. I'm talking about the Speaker of the House. All public figures must either they have a private account or they have a public account. If they're posting something about public actions, their public life, then that becomes a public account. And if it's a public account, you can't ban anybody. So these are some of the principles of our bill and my report, which is at the lower house at this point. At this point, there are only some comments on, I hope that they don't touch the pillar of our report, which is traceability, as well as prepaid SIM cards. So we stop this proliferation of criminal activity that at the end of the day, the telecoms are giving them their criminal weapons, which is a fake SIM card with a fake tax number. I apologize if I was not clear in explaining the chapters and articles of this bill. Thank you so much, Senator Colonel. You have been very clear, and it was very interesting for all participants. And from your explanation, we can start thinking on a number of issues, especially in intellectual property, and making sure that there is transparency and private information and so on. ABPI usually sees in a positive way the initiatives that are going to help fend off excesses and violations. I agree with you that freedom of expression is not an absolute right above all other rights. I think the federal constitution lists a number of rights, and they have to be interpreted in a harmonious way, and one limiting the other and serving as a counterbalance to the other. Freedom of expression may not can't be considered. When you finish, I just need a small comment. That is very important. Don't let me forget. Go ahead. Go right ahead. I have just received my wife's message. Don't forget to talk about 1 to 1 and 1 to 5. That's correct. When you're speaking between you and I, there's nothing really breaking privacy and encryption. You're completely end-to-end encrypted because people are worried about the secrecy of sources, especially for journalists, 1 to 5, 1 to 1, 1 to 5. The problem is when you post something and these 5 placing what you posted in a group of 256, that is above 1,000. So the bill as of the 1,000, if there is a video viralizing, smearing someone, the victim may ask the justice system to get a court order for WhatsApp to find out what the source is. If I share with you another 3 people and each one of you place on a group of 256 by a list and you're beyond 1,000, if somebody complains and prosecutes you, it's not going to go through you because metadata goes right back to the original posting individual. So I just wanted to make sure that this is clear so we keep our freedom of expression because it's an untouchable article in our Constitution. But for digital criminals, for people that don't have the courage to criticize people face to face, our system agrees with that, except that people cannot do this anonymously. Thank you so much. Just some points I want to stress that are very positive in your explanation is that we should try and find a balanced way of dealing with these issues. And obviously, transparency from platforms is really recommendable for the population. And actions against robots and illegal behavior is also very positive in your bill. Identifying people who are responsible for accounts is critical so that people are face justice, smear material. These are basic principles we need to understand. Having clear rules to remove content violating rights. So ABPI sees this with a good, in a positive way. Also, those paying for content and the measures against that seem very adequate and needed. You know, the difference between private and mass communication is also at the heart of the bill. And it seems to me that this is bringing innovation and helping foster more adequate behavior within communication vehicles. I'd also now like to give the floor to Arthur Coimbra and ask him, and now already going into the debate phase, and ask him how he sees the approval of this bill and if there are ways of improving it as an expert so that during the phase at the lower house. Well, thank you so much for your question. We follow this quite closely. All the bills that have anything to do with telecommunication and internet environment, and the 2630 bill is obviously followed by us closely, both in the lower house and at the Senate. The original idea of the bill, between the original idea and the approval and enactment, there has been great evolution, and this has been positive influences of a debate, and we see it as evolving from the original idea. And we believe that within the legislative process, it's still going to evolve. It's always a challenge when we're dealing with bills that have something to do with a very dynamic, a fast-changing sector of the economy. It's hard to find a balance. The ideal balance. when it comes to structural measures and situational measures. When we talk about WhatsApp, we should have these elements in mind. Social media within the next 5-10 years. What will be the applications and technologies that are going to be available on the internet? So it's very difficult to design laws that actually last a long time in this environment, thinking that the legislative process as a democratic process takes a long time. So it's difficult to manage to have it lasting. So, but this we have managed as we debate in the lower house, at the Senate, now at the lower house, then these elements are improved and compared so that the law will last and be updated for a long time. So I think this evolution has been positive. I just wanted to ask our participants who would like to ask questions, please go ahead and send them through the chat and we'll try and answer them as possible. One point I'd like to go back to asking the senator, I have seen in advertising in Brazil, advertising agencies and players, advertising players have raised the questions that seem to be very difficult to implement, but this is something that they claim. On this point, I'm going to mention that you have probably considered, Senator, when reviewing the bill, which is enforcing Brazilian law of advertising disseminated in Brazil. They are asking that when improving the bill, so if you have to have the forcing of enforcing Brazilian law on advertising disseminated in Brazil. The thing is that the digital environment is everywhere. So it's difficult to link it to a territory and place it under Brazilian law. Senator, has this been discussed in the Senate? And what's your position about this? This topic has not been discussed in the Senate. I know that there's something in the lower house. I have something on copyrights. If you're a journalist and you write an article and that article is used by social media, well, they're making money on it. So the author doesn't get any money. So this is what we're regulating. And we are including that copyrights must be paid for works that are produced by the authors. The thing is, a journalist, when they sign a contract with a broadcasting company, they waive that amount in case these companies, yeah, but that is an issue of negotiation between in a contract between the company hiring them and them. So that is not our area. However, today, social platforms are not paying the intellectual property copyrights. And this is a bill that I have been writing, and we want to include this in copyright laws. For 2630, we also, I removed the criminal parts of the original, all the classification of crimes, and I created new criminal classifications in a different separate bill because the 2630 bill is very controversial. So if you add money laundering, smearing campaigns on the criminal sphere is going to create a lot more controversy. But there's something I like to say, A smear campaign at a work environment with up to 200 people, it has a potential. Can you imagine this on a social media? It goes everywhere. You can't have only 6 months of imprisonment. Now we're changing it to 6 years as a minimum imprisonment period for people carrying out smear campaigns and social media. It's a major difference doing it at work or doing this on social media. So I am not reinventing the wheel. That's what people say. This is a very different story. Today, there's smear campaigns on the internet, and the spectrum and the consequences are very different. And this is for enforcement, and what we are really fighting for. We want to punish people that believe they're Superman and Wonder Woman, that they can do whatever they want without being punished, using their anonymous identity to smear people. We can't tolerate this. When we find who they are, they need a lot stricter. If you do that and you pay a number of bags of rice, it's really not any punishment. So let's try and separate these two topics and see if we can treat them separately. The first one is the issue that the center talked about, broadcasting and newspaper companies paying for copyrights. What is your position in this sense? This topic goes way beyond the Department of Telecommunications, because we are more focused on dissemination of internet access and regulatory issues, and that has a major impact on culture. And we work with the Ministry of Culture, the Ministry of Economy, relating to intellectual property. So it's not the telecommunications department that is going to decide what the government is going to do about this. But this is a complex issue. We don't have a firm position on it. We're studying this. But one key to the debate lies in what the senator just said, which is the reach, the outreach in any of the discussions we carry out on the crimes on the internet and issues of intellectual property. When done in a small scale, it has a certain consequence, but when it's a global scale, it's a completely different approach. I have a very simple example when I discussed this at the ministry. For example, books. I bought a book from an author. I bought a number of books from that author. I don't have a community library. There is a public library in my neighborhood, and I placed a book there. So I am going to be praised for doing that. But if I buy the same book, I digitalize the books and I create an online free access library at a global scale. What am I doing? This is piracy. So I am sending out this book, and the author gets no copyright. So the key is the outreach, the reach, the scope. So the debate is profound to do everything right.
So in our Congress today, we have 1,200 attendees on the web. And of course, we have questions from the audience, questions that are coming to us. Let me give the floor to Erica, and she will be
asking the questions. Thank you. Yes, I have a question from our director, Dr. Valdir Rocha. Good morning. Good morning. Thank you for the presentations. I have a question about platforms located in other countries that have no presence in Brazil. New platforms are coming, such as TikTok, and there is another one coming from China, also Aspire. And we've had episodes with a Russian platform which hosts all messages in a cloud. So I would like to hear from you, Senator. What is the reach of the new law in terms of such platforms that do not have a presence in Brazil? In our report, Dr. Roberto, we introduced some requirements. At first, it was requested that all platforms should have a presence in Brazil, but there was a lot of pressure from different organizations, which accounted for the fact that I removed this point from the bill. And it's not having a presence here in terms of the headquarters, just a representation. Why did I introduce that? Because I had difficulty in finding the legal representative of platforms. Telegram, for example, I don't know who is the legal representative in Brazil. I was able to do it for Twitter, for WhatsApp, for Facebook IC, but for Telegram, I wasn't able to locate the person responsible. And when you request this platform for information, there's always the excuse that Brazil has an agreement, which is a bilateral agreement between Brazil and the United States, is the MLAT. So communications under this agreement have to be between the ministries when data is requested. Why? Because if you want to have access to data, they would be sent to an inquiry being conducted under the government. So it was not exactly what I wanted, but it was partially met my goal, because now we have this. At first, I thought that not only a representation was needed, but also a presence in the country. In terms of new platforms, we've set a limit to platforms that have over 3 million users. So the small platforms do not need a representation in Brazil. As they grow, they will have a representation. Even TikTok, that is performing well in Brazil, has not reached so far a level that needs them to have a representative in Brazil. But I believe they will do it spontaneously, because the Brazilian market is great. Just to give you an idea, the WhatsApp market in Brazil is the second largest in the world. We are second only to India, and WhatsApp is more widely used in Brazil than in the United States. In the United States, it's Messenger. So the second market is Brazil, and WhatsApp has to be very careful and has to plan for a representation here to respond to these demands. WhatsApp is so important today for the legal life, for the work life, for social life, and you have no one to appeal to in the country. But we hope that WhatsApp will soon be able to meet these demand of our bill, so that we can regulate such services. Still about this topic, Secretary Coimbra, would you like to add something?
Yes, thank you. This is extremely relevant, what Roberto mentioned. And we can look at the existing legislation. There is a case in the Supreme Court that is coming to their consideration, considering the MLAT, whether MLAT disagreement is constitutional or not. But this is not the issue. The issue is personal data protection. If a platform or a person transfer information or data related to any Brazilian citizen, regardless of the platform being Brazilian or non Brazilian, regardless of the data center being located in Brazil or abroad, this information has to be submitted to Brazilian legislation. So there's no point in having a rogatory letter or any other mechanism related to the MLAT. It is the Brazilian law that is effective and applies to this case. And we should respect that. It couldn't be otherwise. Because if we don't do that, we are going to follow a route which we've tried in the past, I think in 2003, when we were trying to contemplate that any data of a Brazilian citizen operated by a company should have a data center in Brazil. And this doesn't make any sense from an economic view nor political. This is an interesting point. Let me establish a correlation with the area of industrial property. The rights of industrial property may be acquired by a foreign citizen or company without the requirement of being in Brazil. You only need a power of attorney so that the whole procedure, including rogatory letters or any other system that has to be put in place, be made easier. I always defend the following point. If you are making money in Brazil, you have to respond to the Brazilian legislation. I cannot accept excuses from giants of telecommunications such as Facebook because they are operating in Brazil, making money in Brazil, but they don't want to comply with Brazilian laws. They want to respond to the laws of their own original country under the excuse that they have no branches in Brazil. I think the law should apply to them. And I have also been told that TikTok already has over 7 million users in Brazil. So TikTok, if our report is approved and turned into law, TikTok would be under this requirement. Erica, any other questions? No more questions here or on the chat. I think we've covered this topic. Let me go back then to bring about another topic that is certainly going to be discussed in the by our representatives, and it's related to the existing platforms, the internet framework, the way and the consequences that are contemplated to remove content when an aggrieved party requests so. This is the notice takedown. In addition to that, should we have in the bill any discussion on the responsibility of consequences if the content is not removed, if this offensive material is not taken down? In our bill, we've introduced a penalty of 10% of revenues of platforms that fail to remove the content timely. And these resources would go into digital education through the agency Fundeb. Of course, if it is encouragement to violence, suicide, self-mutilation, pedophilia, platforms have to take it down regardless of any notification. But if Luis, if you feel offended and you notify the platform notifies the source. And if this source, the person responsible does nothing about it, the platform will have to pay, because we should not let them think that they are all powerful and no subject to penalty. I was very surprised that during this debate of fake news, to see that platforms has a mega lobby all over the world. It sounds as if platform are associated to Jesus Christ. They are the only ones who are acting correctly, or who have the rights. And what we've seen is that advertising was removed from Facebook due to the amount of fake news. And that was a wake-up call, and they decided to adopt some measures, and we expect them to adopt even further measures so that we can try and banish those who engage in this type of crime, offending families, products, and causing damage to health and other aspects of our life. Any comment? Yes, this comes up often in law in terms of the responsibility of the intermediaries. For example, the mail. If the mail delivers an explosive and it explodes when it reaches the user, what is their responsibility? This was also discussed when we discussed the internet framework. There is the provider of connection and the provider of the application. An illicit content should not be the responsibility of those who are providing internet access to that user. And we have that concern when it comes to the investment environment in Brazil in terms of attracting data centers. Brazil has invested significantly to attract the data centers to the country. And one of the issues that has to be accurately considered is that if you have a data center in Brazil, there are certain responsibilities, because if a client hosts criminal information in that data center, what is their responsibility? Are they responsible for that? Are they accountable for that? So these questions come to the surface in different areas. And of course, app provider, or the ones that are not responsible for the content, but that somehow participate in the transmission, they may be held accountable in certain aspects, but not in terms of the merit of the content. So if they fail to identify something, yes, they may be accountable for that in spite of the fact that they did not generate the content, but otherwise, no. We are getting close to the end, so I'd like to ask you to make your final comments. I heard attentively what Dr. Coimbra said about the mail. And I agree in part, because the mail is not aware of what is being sent, and the platforms do. So we have to be very careful. From the moment you publish something on Facebook, on Twitter, this becomes visible, public. So platforms have to be held accountable to a certain extent and pay the penalties, because they are conveying something that is visible, disclosed. It's not inside a letter. But let me tell you that I'm always ready and available to discuss this topic. It's such a dynamic topic. Maybe the next time we get together, there will be new points. The digital world does not move ahead, it flies ahead. And there are countries that are considering our suggestions on traceability and having the SIM card validated upon presentation of an ID number. So maybe like the internet framework, this one will be a model for other countries. In spite of the discussions, there's no perfect law. France, Germany they have tried, also countries in Asia, but unfortunately, we have not reached the ideal point. But I like to say that to reach the ideal, we have to take the first step. So the Congress is ready to meet whenever is needed. The LGPD exists as well as the internet framework, but the internet framework has been effective for some years now. There are some changes, but let me say it again. Internet and the digital world, we can never say that it's so subtle and it's there to stay. I think every year or even in less time than a year, we have to get together. We have to discuss, we have to hear about what is going on in the digital world. Thank you so much. And thank you, Dr. Coimbra, for your comments. You are a very bright person and very focused on these issues. So I'm happy to see that. And I'm happy to see that ABPI is highly committed to having a digital world without free of any criminal activity, so that these digital systems can serve their true purpose. Thank you, Dr. Coimbra. Thank you once again for the invitation to participate. Thank you, Senator. I am very pleased to see this discussion. The project is the bill is a high quality bill, and of course we, as occurs in any democracy, this is subject to discussions. It's being discussed. It's now being considered by the representatives. It will go back to the Senate. You've explained the process, but we have to consider that this is a problem that is natural in democracies. So it only shows that Brazil is a live and strong democracy, and that this topic is being discussed as it should in the Senate, in the Chamber of Representatives, and elsewhere. So we from the Ministry of Communications, we are closely following up on these developments, and we are ready to cooperate at any time. I'm sure that the discussions in Congress has been highly positive. Thank you, Dr. Coimbra. And Dr. Coronel, this is a very important topic. We will follow closely this issue nationally, and also in possible discussions of an international treaty that may somehow internationalize this topic, so that we can have rules that go beyond borders, because we are dealing with a technology that is ubiquitous, digitally free of any territory, and that where other issues that were regulated internationally, and we've reached an agreement. So at ABPI, we will follow this effort, and I hope to be able to count on you in the future, Senator and Secretary, so that we can further discuss this point. And Erica, you have the floor. Thank you. Excellent plenary. I'd like to thank you for being with us until now. We are going to conclude this plenary, and at 11 o'clock, we will have a discussion on the protagonism during the times of COVID and arena rights and broadcast rights. They are simultaneous panels, but you can access it in our platform anytime during the event. Thank you.
Depende dos demais. O desafio é aprender juntos os novos caminhos da transformação digital. Fazer diferença com inovação, empatia e coragem. É com esse espírito que a equipe da LD Soft está aqui pronta para ajudar você a fazer cada vez mais pelo seu cliente, oferecendo meios para você trabalhar com mais produtividade e eficiência, mesmo nas condições inesperadas do trabalho totalmente remoto. Nossas ferramentas oferecem aquilo que você precisa para dar atenção a tudo que realmente importa e que só você pode fazer. Assim, ter tempo para oferecer ao seu cliente os resultados de excelência que ele sabe que vai receber de você. Por isso, vamos continuar firmes, para que em breve possamos destampar nossos sorrisos e comemorarmos as novas conquistas juntos nos desafios que estão por vir. LD Soft, potencializando o universo jurídico através da tecnologia.